NACDL is the association of the nation's criminal defense bar.
Now, without further ado, I would like to turn it over to our first presenter, after all that, who's going to tell you about litigating Daubert Frye issues and post-conviction cases. Now, Jack Cunha is a partner at the Boston firm of Cunha and Holcomb, and he focuses on litigation, obviously particularly criminal defense and appellate litigation. He's a former clinical instructor at Suffolk and Harvard Law Schools. And a little bit about his Daubert experience, which you'll hear more about shortly. In one of two federal RICO cases in which he prevailed at trial, U.S. v. Green, his Daubert challenge to their so-called ballistics testimony precluded those government experts from testifying that they had determined crucial evidence from a shooting scene matched a handgun that was linked to his client. In Commonwealth versus Patterson, post-conviction, in both the trial and appellate courts, his Daubert litigation and challenges excluded simultaneous fingerprints, the key evidence against his client charged with the murder of a Boston police detective. We're happy to have this great expert, so I turn it over to Jack.
Well, I'm kind of nervous about this. As I've been saying to people, it's always difficult to speak to one's peers. And I've got a lot of experience actually speaking around the country at CJA trainings and actually state sort of analogs to NACDL in the areas of ballistics and fingerprints and cell sites, which I find a lot easier to talk about because you got a topic, you can tell people what the problem is, and then you can give some thoughts about how to attack it. Now, so I'm going to be talking a little bit about ballistics and fingerprints, but I would like to say that if anybody has those specific areas, feel free to call me because I'm not going to be delving into how to attack those areas. I'm going to try to give a broader perspective on Daubert and Frye. So one thing I'd like to know is how many trial lawyers do we have here? Okay, and how many appellate? Okay, and then how many of both? Okay, all right. So, all right. Well, that's sort of your demographic. It sort of fits me. I'm mainly a trial lawyer. I have done appellate work, and so I've seen it from both sides. And I think that it's obviously also as an appellate lawyer, if you get a new trial granted, now all of a sudden you often find yourself in the position of being the trial lawyer. All right. So, as we know, expert testimony is ubiquitous. This is based on a study of Peter Newfield and Brandon Garrett in 2009. I think that the most important thing here is that all expert testimony was admitted, rarely over objection. We also know that error in forensic sciences is a real problem. This is a study of Brandon Garrett, or a paper he wrote in 2008, and it is the second. Expert forensic testimony errors were the second most, the leading type of evidence in wrongful conviction cases. So I just want to very briefly go over Frye, Daubert, Joyner, and Kumho Tyre. I've highlighted this here, right here. Obviously, that's what everybody thinks about Frye, and that is whether something has gained general acceptance in the so-called scientific community. It's my premise, and I'll be talking about this, that's the essential problem with Daubert as well. And there you have the so-called, I mean, people fight about how many Daubert factors there are, but I went with 4. I think the one that for forensic examiners is the most important is the same as the Frye factor. That is the general acceptance. I don't know because I don't try toxic torts or other types of areas in civil cases. As we know from, I believe it was Peter Newfield's study and also the NAS report make very clear that the same judge is going to be very fastidious in terms of admitting things in a civil case and is going to allow the government to put in whatever the hell they want in a criminal case. So I'm going to talk about, you know, whatever the distinctions may be between Frye and Daubert in civil cases, I don't think they really apply in forensic so-called science cases. Now, General Electric versus Joyner is the second of the so-called Daubert trio, and this quote, which is the federal rules of evidence allow a somewhat broader range of scientific evidence than would be admissible under Frye. I think that that's just not true in the criminal law area. And by the way, at the bottom of these, I make reference to some law review articles which aren't, I mean, which I've provided to you, and I think they bear reading. Now, and then there's Kumho Tire. Now, Kumho Tire, as everybody knows, sort of everybody focuses on this, that the gatekeeping function applies to all areas. I think the more important part of Kumho Tire is these three areas, which, at least in the criminal context, have been ignored, I think, by the courts. And in particular, the fact that you need a task-specific focus. That has been kind of lost. The importance of looking at what does the government seek to admit here, or what has the government admitted here? That is really the focus. And this very quickly, Daubert is 25 states, Frye 16, combination 6, and you know who knows what 4 states. That's as of July 2001. All right, so in looking at Frye and Daubert with respect to the forensic sciences, I'd suggest that there are two things that really happened. One, when DNA came along and the courts started seeing what real evidence was, then it was a shock to certainly to litigants, but even to judges. And then when Daubert came along, there was now a willingness to re-examine, you know, previously sacrosanct, unchallenged disciplines. Okay, the question is, however, are there really material analytical differences as applied between Frye and Daubert as applied to the forensic sciences? One of the, I think the only case that, at least the only case that I know of, in which fingerprints were held to be inadmissible was State versus Rose. And it was a case that arose in, no pun intended, in Maryland. A state court judge, after a hearing, and Maryland is a Frye state. After hearing, the latent fingerprint testimony was excluded, not limited, but excluded. And why, if it's a Frye state, since clearly the scientific community is, if you consider that it's fingerprint examiners, that shouldn't have been excluded. But again, because of this new willingness to challenge things, people are challenging this kind of evidence in all jurisdictions with with standards that differ. But ultimately, I'd suggest they come down to the same thing. And by the way, what happened in Rose is that the state dismissed the murder charges against Mr. Rose. He was then indicted by the feds. And guess what happened at the Daubert hearing in federal court? You got it. Judge said no problem with this stuff, and the case went forward with the fingerprint evidence. Now, analytically, in place of Frye's test of general acceptance, Daubert has a test of evidentiary reliability. Okay, and so therefore, if the science is sound, in theory, Daubert will admit more than Frye, and the opposite is if it's a newer. This is what well, excuse me, in the old fields, Frye will admit more than Daubert. That's the theory, right? So fingerprints or ballistics or hair analysis or all these things that got admitted without any question, in theory, those should still be easier to admit in Frye than in Daubert. However, there has been a distortion of the empirical focus of Daubert, Kumho, Tyre. And that is that they've turned the process of reliability evaluation, which the Supreme Court envisioned as being empirical, data-driven, and specific, to a single global resolution. And that's something that is a problem, but you have to challenge it. I'm suggesting to you that in the forensic sciences, Daubert and Frye are really not very different at all. And in fact, they're the same, all right? Reliability really is the touchstone for both Daubert and Frye. The Frye reliability is supposed to come from the fact that it's accepted in the scientific community, okay? And, you know, fundamentally, except for the gatekeeper function and application of this examiner to this case, they're really the same approach. And the common core problem right here is what group do the courts recognize as the quote-unquote scientific community? This is a quote from a law review article by Paul Rice, who's is now deceased, but I kind of liked it just because it's so direct. The reality is that judges are compelled to return to the same relevant scientific communities for answers. Daubert is little more than Frye in drag. And there it is again. That is the problem. They look to the same scientific communities. And that's why I suggest to you there's no real difference in terms of as applied in Frye and Daubert jurisdictions. And now we have the skew problem, which is that there are very few appeals by the government when their evidence is excluded, if that even happens that often. But certainly if it does, it doesn't rise to the appellate level. So what you get at the appellate level are discretionary decisions, okay, because it's an abusive discretion standard. We know that at least in Daubert jurisdictions from Joyner. And as a result, there's a skewed effect that when a discretionary decision is upheld at the appellate level, all of a sudden it becomes this field has now been judicially blessed. And that's something that you have to be aware of and you have to fight it. Even though Joyner says that appellate courts may not categorically distinguish between rulings allowing expert testimony and rulings disallowing it, the fact is they get very few opinions in which it was disallowed and it was brought by the government. Okay, a real problem, and I think you need to be aware of it, and I think the courts need to be educated about it, is the fact that the law enforcement has manipulated and tried to control so-called forensic sciences, right? And I've cited there Paul Gianelli. That's one of the law review articles that you've been given, and I'd suggest that it's worth a read. And basically, I mean, I don't know if you folks have seen this, but I have, and people that I know, whom I won't name, but someone who testified for me in ballistics, for instance, someone who testified for me in a fingerprint case. As soon as somebody in the guild, because that's what these are, they're guilds. They're self-perpetuating, self-defining guilds. And as soon as somebody testifies differently, they are the subject of attack. They're the subject of attack by so-called experts. They're the subject of attack by prosecutors, and they're often the subject of attack by judicial opinions. The extent to which science is supposed to be open, right? That's the whole idea of a peer-reviewed journal. It's supposed to be open, but in fact, it is closed, and the law enforcement community is very upset about the fact that they are now being forced little by little to open up, and you've got to continue that process. Here's an example. Bill Tobin, who's a retired FBI analyst, he challenged comparative bullet lead analysis because, for a number of reasons, but one of which was the FBI examiners who would testify would give opinions ranging from, well, this is the CBLA in this from the defendants from evidence seized from the defendant is analytically indistinguishable from that at a crime scene. That ranged all the way for that to it had to be. This came from the same batch, the same box, okay? So when Tobin started to challenge this, the FBI asked the National Academy of Sciences to look at it. And a couple of things happened that were very revealing. One of which was that they wouldn't turn, first of all, they wouldn't turn over their data. They said they had this huge data, it's like 70 some odd million items in a database. They didn't turn it over until right at the very end when it was really too late to put it in the NAS, in the report that NAS did on this. But then when they didn't turn over the whole database, and there were all these problems with it, including the fact that it looked like they had culled out problem results. They then attacked the NAS, which said that there's a problem with this, because the NAS said that if you find that there's a correlation between the amount of what is cadmium, lead, there's like 7 different things that they look for in this CBLA analysis. What they said is that when, you know, the fact that it came from the same box is ridiculous. There could be as many as 35 million sources that would be the same as in any given case. So it's a lot different from saying, well, it could be one of 35 million pieces of ammunition as opposed to it came from the same box. So the FBI attacked the report. A year later, they stopped doing this analysis, which seemed to be a tacit admission that there's a real problem with it. Yeah, but what did they do? They refused to reveal those who were convicted using the process, and they even wrote an affidavit supporting the process. This is after they used it. That is manipulation of evidence. All right, let's see, what's this? Okay, here's another example. There was a National Institute of Justice solicitation in 2005 seeking concept papers to look at forensic sciences in a variety of ways, you know, including whether or not it was accurate, you know, and what tools. I mean, it was supposed to be a comprehensive look at the subject, and what happened to that proposal? Well, what happened, and obviously the fourth one of the things they wanted to look at is very important: the unique forensic characteristics found in impression evidence. So fingerprints, for instance, tool marks, which we call ballistics when it's applied to weapons. This was going to be a very important study. What happened is the DOJ demanded veto power over the content of the final paper. They weren't going to give this stuff up, all right? So what happened a few years later is that Congress bypassed DOJ by passing a law funding NAS to conduct a study by the National Research Council, and that's what we know, and this is the result of that. All right? It was only when Congress bypassed the Department of Justice that we got this very important report. I assume everybody in this room knows about this report and has a copy, right? If you don't, you should. And another thing to know about this is that right here is the site to it. You can download a PDF so that if for instance, if you want to use it for evidentiary purposes, you don't have to give your book you don't have to put your book into evidence. You can put the PDF in. This is also for ballistics imaging. I'm just going to show it very quickly. This was a very important, also an NAS study that called into question a lot of the assumptions that were relied upon by so-called ballistics experts. So what did NAS report tell us? That there were serious shortcomings in the capacity and quality of this evidence. And here's the problem, and this is why we're here today. The courts continue to rely on forensic evidence without fully understanding and addressing the limitations. And the bottom line is simple, that these professionals have yet to establish either the validity of their approach or the accuracy of their conclusions, and the courts have been utterly ineffective in addressing this problem. And that, of course, is only on the criminal side. On the civil side, it's very different. Okay, and what else did we learn? That individualization is a myth, except for DNA, and I won't get into the problems in which DNA has its own issues, but obviously very much fewer than in the other so-called forensic sciences. There's also a lack of scientific method in these in the forensic discipline, except for again DNA. This stuff now. I'm not saying that you shouldn't try to attack these areas if you've got a forensic if you've got forensic evidence, but the courts pretty much don't care about this stuff. That's been my experience. So I think that what you really need to look at is how is the scientific community being defined? And in general, of course, in Frye, it should be the broadest because it's the scientific community generally. At least at least in New York, and every Frye jurisdiction is slightly different. And I've seen reference to 3 or more different flavors of Frye. But in general, Frye is looking to science, and whereas Daubert, particularly after Kumho Tyre, it's a more narrow, discrete field. And in Daubert also, in theory, no one factor is dispositive. And I say in theory because I do think that it really is a matter of, for both, that they look to an extremely narrow, insular, self-defining community, and that's something you just have to attack. Now, one of the things that we want to look at is what is the burden of proof? Daubert does say that, to some extent, there has to be a preliminary showing, but in general, obviously, in any evidentiary situation, the proponent of the evidence bears the burden of admissibility. However, in a number of cases, and I've just cited a few here, the courts make the challengers bear the burden of admissibility. And again, that's something that you just have to fight. The last thing there, I've noted that's the Rose case, which was one of the few that said the burden is on the proponent. And of course, that's the one in which the fingerprint evidence the latent fingerprint evidence was held inadmissible until the federal case in which it was admitted, and the same evidence, same defendant. This is something I just came across. It's obviously not the law anywhere that I know of, but I thought it was interesting, and in the Friedman case is in the materials. And what this guy argues, in part because of the problems with these so-called forensic sciences, that the burden of proof should correspond or correlate with how easy or difficult it is to admit. Now, I don't know whether you want to push this, but I thought it was very interesting, and it makes a lot of sense to me, quite frankly, that it should be harder for the government to get this junk in than it is for the defendant to offer evidence of, particularly where it's questionable as to how reliable this evidence is. And so I give it to you for your whatever, any use you want to make out of it. The bigger problem is the grandfather problem, and that is that, again, the courts are loath to exclude forensic evidence, which, after all, has been very helpful in putting people behind bars for over 100 years. And the judges don't want to give it up. They like that. You have to fight it. You have to point it out to them. The judicial rationalizations include that the forensic sciences form relevant scientific technical communities. The reality is that these are overwhelmingly practiced by law enforcement or retired law enforcement, and that's a real problem for the defense bar, and particularly because I have yet to find a defense forensic examiner who's willing to say, my life has been a fraud. You know, I was on the road, you know, to Damascus, and I realized that this stuff is nuts. And I'm here to atone for my errors, okay? If you find that person, they're going to become rich, and everybody in the country is going to want to use them, so call me first, okay? So I say, is what about astrology? I mean, that's something where they've done real measurements for thousands of years, okay? Now they're based on a faulty premise, which is that you know, there's a movement from side to side rather than a revolution of the Earth. But this is a field that actually measures a lot, all right? And Kumho Tyre says whether the expert is competently using procedures accepted by others may be of no import. This is not a quote. If the reliability of the area as a whole is being challenged. And this is one of the things, again, you got to go, I think Kumho Tyre is a really important opinion that has not been utilized enough. So you really need to go back and just say, yeah, it's accepted in this little guild niche, but that doesn't matter. So, and here's the astrology analogy from Kumho Tyre. Nor does the presence of Daubert's general acceptance factor help show that an expert's testimony is reliable where the discipline itself lacks reliability, as, for example, do theories grounded in so-called generally accepted principles of astrology or necromancy. I don't know a lot about necromancy, but, you know, this is what you got to try to push to the courts, that this stuff is akin to astrology. In fact, astrology might even measure more than they do, and this is an example of now of a narrow community. Does everybody know about the Yarrow Plaza decisions? There were two of them. People know about this? This was one of the first, if not the first, challenge to latent fingerprint evidence brought by Rob Epstein out of the Federal Defender's Office in Philadelphia. And the judge, Judge Pollock, sent, you know, this seismic blast through the fingerprint community when he excluded it after hearing, because he had the temerity to apply the Daubert factors. And of course, latent fingerprint analysis just doesn't make it under those factors. And the government went nuts and asked for reconsideration. He reconsidered and he let it in. And basically what he did is he said that, you know, it's personal experience versus science, and therefore within this guild, it's okay, and I'm going to let it in. And this is exactly the problem that you have to fight. And again, you have to challenge the composition of the so-called scientific community. Now, there's some good news. Actually, I was just told this morning that what was that? Could you tell the group what the? Yeah, the Rockefeller bill. Yeah. Could you stand up just to tell people? Because I don't know about this. I need all the help I can get up here, people. Right, but it's a sign of potential progress. And obviously, it's one of the things that the NAS, the 2009 NAS report on the state of the forensic disciplines asked for. However, there also are some other developments that are not dependent upon Congress. One is that DOJ and the Commerce Department's National Institute of Science and Technology and NIST, those people use real numbers, they measure things, they have real scientists. So the fact that DOJ is now partnering with NIST, I'd suggest is a very important development. It's something you can also cite to courts. Why are they doing this, Judge? They're doing this because this is an implicit recognition that what they were doing before was not sufficient. All right? And in these, they're actually going to have, in addition to forensic examiners, which used to be the whole of the community, they're now actually going to have research scientists, academics, and also advocates, including for the accused, which includes Peter Neufeld, who's the co-director of the Innocence Project. So that is a very big development, I'd suggest, and it's in its nascence, but we hope that something is going to come out of this. I also found this quote on the White House site. Now, what Obama's White House says about forensic evidence may not be all that persuasive to judges, state or federal, but it was very interesting to me to show how far things have come, that the White House is willing to say that the reliability of forensic techniques and practices varies widely, and cites the NAS report in any way whatsoever. So I think things are changing. Now, in addition to that, you also have the Organization for Scientific Area Committees, OSAC, and again, DOJ and NIST had a memorandum of understanding just a few months ago. Now, this is going to change. There are these things called SWIG groups. Do people know about SWIG groups? Okay, SWIG groups, you got SWIG Fast, you got SWIG Gun, you got SWIG this and SWIG that. And they basically were FBI organized and controlled areas for forensic sciences. And they were run by and loaded with examiners. That's it. And they supposedly were developing standards of both practice and examination. And they were just insider groups. They were just guild groups. Now they are, in fact, again, opening this up to other people by involving NIST. And they're going to have these guidance groups. So you're going to have real scientists, hopefully, who are going to be weighing in on these bogus sciences. And again, this is something I think you can cite to the courts. This is brand new. You also have the Forensic Science Standards Boards, 16 members, so that no single interest predominates. There are going to be 5 Scientific Area Committee chairs. You're going to have your same, guild representatives there, okay? But you're also going to have 5 at-large members from research and measurement science communities. That is a huge difference, okay? You're also going to have 1 NIST ex officio non-voting member. Again, I think that this is an implicit recognition that this stuff is bogus, and it doesn't matter whether you're in a Frye jurisdiction or a Daubert jurisdiction, because again, this goes to what is the scientific community, and it appears that that definition from a law enforcement perspective is starting to open up, and the courts need to know about it. Okay, so here's another thing, and this is just very briefly. If you have these questions, if you have a case, one of the things that you want to look at right away is, has the science changed? Arson, for instance, has changed a lot. CBLA, voice print, shaken baby. But you also can use these areas to say, Judge, we've found that in these areas that the so-called science that have been used for years and decades, it was just plain wrong. And that's one of the reasons you need to look at this area. Use this as an analogy to say, we've been fortunate enough to discover in these areas, and any other that you can come up with, that there's a real problem. And again, I don't think it matters whether it's a Frye or a Daubert jurisdiction, because it relates directly to what the scientific community is. And the fact is that if the courts were just looking at the guild members in these areas, there wouldn't have been any change. It was only when the courts were willing to look at broader science, and that's something that you need to emphasize. All right. Now, I'm not going to get into ID evidence, but there's a couple of interesting law review articles that talk about Daubert gatekeeping for ID evidence, and obviously, mistaken IDs is the single greatest problem in wrongful conviction cases. So I'm not going to talk about it, but you may want to, just make note. I think that this is going to go up on the web, so if you don't have to take notes. Also with respect to these guild communities, you have to attack them because there's this, trust me, I know it when I see it, that's what these practitioners basically say, based on my training and experience. Nothing else, really. And again, go back to Kumho tire. Some of Daubert's questions can help to evaluate the reliability even of experience-based testimony. So you can use the factors even if they're saying, one of the things that all these people wanted to say was that they were scientists. And then when they found out that they didn't have any science, they're saying, oh, no, we're experience-based. But you still can try to use the same factors to attack. And a quote from Joyner, nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the ipsa dixit of the expert. That quote alone should have wiped out whole vast areas of these forensic sciences, and it hasn't. But you have to bring the courts, your judge, back to this premise. All right, and this was actually a transcript from Green when I like to do this to these people. I ask them if it's a science, and they love to say yes. So then I say, what's science? And you know what? I haven't had one yet who could give any kind of an answer. Now, I think it's more effective in front of a jury. But a judge should know this. I ask them, what's science? They can't answer it because they don't know. All right, so I think that in all areas where you've got experts, you have to look at what the underlying assumptions are. And that's the most fertile area for attack. You have to look, what are you assuming? All science assumes something. Even the real stuff, physics, chemistry. There are certain assumptions that are made. There are fundamental assumptions. And if you look at what the fundamental assumptions are in your area, you're going to figure out where you need to attack. I mean, here's an example from that ballistics imaging book I showed you earlier. And the fundamental assumptions of uniqueness and reproducibility, it has not yet been fully demonstrated. If you can't prove that, then what the hell are you doing up there, sir? All right? So here, let's look at firearm examiners, so-called ballistics. The stated assumptions are that unique marks produced in the manufacturing process are reproduced and then transferred from the weapon, which becomes the new tool, to the bullet or to the casing. One thing to know is that permanence is not assumed, and the other thing, they do assume that it is a science and uses the scientific method. The unstated assumption, and this is, I think, a real problem in all the impression sciences, is that they say that identification can be reliably determined from a very small area of a projectile or shell casing. Why do they say that? Because in the guild, that is what it passes for truth. Again, you need to open up the community. So here's the AFTE theory of communication, and just very briefly go through this, which says, and this is off the AFTE is the American Federation of Toolmark Examiners. This is off of their website. And they say that something has to have sufficient agreement, and the agreement is significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. What the hell does that mean? All right? Well, that is, and by the way, they acknowledge that the interpretation subjective. I'd suggest that the whole process is subjective. But the second thing is what they call the best known non-match. And basically what it is, and it's important to know this, because what it understands that the same marks made from different tools can appear. So if firing shells, for instance, from different tools, they can have a certain number of marks in common. So the examiner is supposed to have a database right up here, all right? Every single one of them. And they consult that database. Are there more marks on this than are consistent with something that was fired from different tools? Okay? And if it is, then it had to have been fired from this tool. All right? That's nuts. But that's the basis of what they do. Here's what the NAS, the 2009 report said about it. Okay? It's not reliable. And that's what happens when you let a self-perpetuating, self-defined community be the one that the courts look at, whether you're in Daubert or Frye. All right? Oh, I think this is the same thing again, just a different one. Okay. Now, here's again a question I asked the examiner in the Green case. I said, you know, how do you measure sufficient agreement? You know, science measures things, right? And again, he admitted it. And I think that more important or better in front of a jury, but a judge who's considering these issues should also, you know, make them say it. This is an important thing in ballistics. This guy Biasotti, when he came out with this study, first they all hated him. Now he's one of their gods. But it's interesting. What he did is he did it for a master's thesis. He looked at a bunch of he fired, I think it was eight used Smith & Wessons and 8 new ones. I can't remember how many of each. And he looked at it, and what was really shocking is that he found that 15 to 20% of the bullets, you know, these striae, the scratches, that's what they are, the scratches on the bullets, that 15 to 20% were matched, even though they were fired from different weapons. What does that mean if you're only looking at a very little part? Is this a part where they match even though they're from different weapons? Or is this a part that matches because maybe they're from the same weapon? Well, I can tell you that they're from the same weapon because of my training and experience. I know it when I see it, right? The other part of that that's interesting is that 66 to 79% of the striae on pairs of bullets fired from the same .38 caliber didn't match. I mean, that's shocking to me. So that means, let's see if I can do the math in my head, 21 to what, 34%, you know, did match as opposed to 15 to 20, which didn't? How can anybody give a reliable opinion based upon those things? That's beyond me. Of course, they say that there's independent review, so again, I asked some questions. You want to ask these questions. So if you make an identification, because they've all adopted this verification business. And so, and of course, what happens is that they never ask somebody to verify when they don't find a match. They only ask you to verify when you do find a match. So you got to ask the questions, all right? Because they're not going to waste their colleagues' time by saying, "I didn't find anything here. What about you?" So what kind of verification is that? I know you found something. I'm going to find something. Latent fingerprints, just very quickly. Assumptions, uniqueness. I don't know if this is accurate, but I've seen it a number of places that there's about 75 to 175 points of comparison on any one digit. Permanence as opposed to ballistics, which is not permanent. And what's unstated again is this notion that individualization can be made from a very small part. So and there's also assumption there that unlike in the ballistics, that there's this methodology they use: analysis, comparison, evaluation. I won't go into it, and verification. And for a description of that, you can see the NAS report. But what's the reality? It only describes the process. Courts come out and say, well, they use ACE-V. It's got to be real. It's got to be accurate. That's just a process. It's not evidence of the reliability of the underlying assumptions. And that's what you have to look for in all of in any field you have. They want to talk about their process. Well, astrology uses a process, but it's not reliable. I didn't cite it, but these two, Haber and Haber, they're in California. I shouldn't say out in, since it's like down the road from you people, or from here anyway. And one of the quotes was something that they looked at all studies trying to show that using ACE-V ensured reliability, and they found none. None. All right, there are 23 cases known. This is from Simon Cole. He's another one. He's, by the way, one of the people who has been under attack. Remember earlier I talked about the law enforcement attack? Simon Cole has been excoriated because he has had the temerity to say, let's look at this from a reasonable, logical perspective to see whether this stuff is reliable. And he's mainly fingerprints, if not entirely. And also interesting down here, I cite this. This article here is looking at the admissibility of fingerprint evidence in Frye jurisdictions. And again, I think that there's no real distinction between the two when it comes to the forensic sciences. Now, all right, so subjectivity versus measurement, something you have to attack as well. And this is from the NAS report, which basically says, you know, what this process does not find. They don't measure anything. So when you're comparing impressions from two individuals whose imprints are unusually similar, how do you distinguish them? I'm not going to talk about Brendan Mayfield, but do people know about Brendan Mayfield case? Yeah, all right. There were 16 points of comparison, according to the FBI. The Spanish said there were few. The Spanish National Police said there were fewer. 16 points of comparison. I've seen it where they say 7 or 8 is enough. 16 to them is huge, okay? How do you know that 16 points of comparison are enough? Because I say so, based upon my training experience. What studies? This is when I did the Patterson case, this was a slide from the FBI. He was the head of one of the 2 FBI fingerprint labs, and he was you know, because there was this back in the late 80s, early 90s, there was a study done by, I think it was IAI, to find out how many points of comparison you need before you could make form an opinion that it's a match. And after 3 or 4 years, they came back and they said, we don't know. So what did they do? Instead of saying, oh, we got a real problem, they said, we're going to eliminate that as a criteria. Now it's this holistic, you know, quantity and quality, all right? Because they know they don't have any real reliable numbers. So when he put this up and he said, this is how we do it. So of course the questions I said is, how much quality is this? How much quantity is that? How much is sufficient? And this guy was really ticked off because I took his slide and I put it you know where. Because he had no answers to any of those questions. How much is enough? They just don't know. And then this is another slide that this guy used. And he said, this is why we don't use numbers. You know, why don't we use points of comparison? Because look, these match. Now this is something he drew, but no, that's okay. That's okay. This is something he did. But look at this. You know, this matches that. This matches this. But clearly they're different. So that's why we don't use numbers. Okay. So I went back to my office that night, and I got the best tool that anybody has, and that's whiteout. And I brought this in the next day, and I asked them some questions about it. And I said, isn't this more like what you see in the field, a partial print? Now they match up. He was really pissed off about this. And I said, so how do we know if on the one on the right is more like what you see in the field, and we don't have the part that we know from the previous slide shows that they're different, how do we know? And again, there's no answer. So this is the how much is enough problem, and I don't know what time it is, but I'm going to just go through this quickly. Look at the NAS report, and basically it says that, all right, now, finding an expert is a real problem, and this is the drinking the Kool-Aid problem we talked about earlier. I just love this thing from the AFTE, the American Federation of Toolmark Examiners. This is on their ethics. This is on their website. And basically what they say is, does that color, that's not a great color on that there, huh? Should I change that? But basically what they say, it's in the interest of the profession that, first of all, that both examiners resolve their conflict. They're claiming that it's absolute truth, but they want you to resolve the conflict. I don't know about you folks, but I have yet to get a report on toolmark examination that says, by the way, originally these people disagreed, but they resolved their conflict. All right? Now that's clearly exculpatory evidence. You're never going to see it because it's ethical for them to do that. Okay? The second thing is, and this blew me away when I read it. I find it easier to find experts in fingerprints than in ballistics. And one of the reasons might very well be this, that although they say that the attorney-client relationship generally applies, what do you mean generally? Except in a situation where a miscarriage of justice might occur. What does that mean? It means, if you look at D, that it shall be, although it's ethical to serve an appointment in an advisory capacity, this has to be performed in good faith and it's not malicious. It's the purpose to prevent incompetent testimony but not to thwart justice. So in other words, what they're saying is that if you are not, I mean, who has used an expert to say, well, I generally find the same here, but this is what you want to use for cross? That's unethical for a toolmark examiner. And in fact, they can violate the attorney-client privilege. They can go to the cops if they think that that justice requires it. What kind of nonsense is that? I want to very quickly talk about bias. Confirmation bias, knowing the identity, being told there's information. This is what happens in most things, and that's why these new efforts to try to divide it, the police function from the expert function, hopefully will actually filter down to the local level, because what happens is, the expert, the so-called expert, who's just a cop usually, goes to the scene. All the detectives are friends of his. In fact, that expert probably was a detective and now, for various reasons, has been promoted to the forensic unit. And it just causes bias, and bias that they don't even know about. I mean, that's the real problem with bias, isn't it? That we're all human, we don't know about it. The contextual bias. I love this. Do people know about this about Etel Dror? A very interesting character he's English. Well, actually, I think he's maybe Israeli, but he teaches in England. And after the Mayfield case, he contacted 5 of the most important, preeminent fingerprint examiners in Great Britain and said, we're trying to, this is a real problem with your profession. We're trying to figure out what happened. So he gave them the evidence from the Madrid case and said, examine this and tell me what happened here. 3 came back and said that these prints just don't match. All right? 1 said it was inconclusive, and 1 brave soul said that it matched. Okay? Dror then told them, well, I lied to you. I gave each of you one of your own cases in which each one of you had made a finding of a match. But given a different context, they came up, 80% of them changed their opinion. And 60% were false positives. So this is something, quite frankly, there's the site to Dror, and he's written a lot about these issues of bias by experts. I wish I had some wisdom on how to use this. It's very difficult in my view. If anybody's got any idea, let's spread it around. Because the problem is that these examiners don't understand that they're biased. You know, maybe using a study like this is helpful. This is the Patterson case that I had, and I didn't even know about this stuff when I had it. After I got Mr. Patterson a new trial, because the government's theory of simultaneous fingerprints had been held not to be reliable by the Supreme Judicial Court of Massachusetts. And so what the prosecution did is they said, okay, because they had 5 examiners, the 5 most preeminent examiners in Massachusetts had all said Patterson's fingerprint was on that door, and it was the door that the detective had been shot 5 times in the head sitting inside a door, and there were fingerprints on the door. Seated inside a car, excuse me, and there were 5 fingerprints on the door. So they sent it off to the FBI. Now, the interesting thing is when the FBI got it back, they said, when they sent back their opinion, they said, this stuff is junk, and we can't form any opinion. But what I didn't notice until I started to look at bias was this is the back of the 10-print card that they sent. What difference does it make that he was arrested for the murder of a police officer? What if it was shoplifting? Okay? So even though the FBI wasn't swayed by this, you got to look at what are the signals that may be being sent to these examiners that are going to bias them. Okay, and that's good luck and good hunting. I don't know what I am in terms of time, but if anybody has any questions.